Good morning, everybody. I think we're running a few minutes late. My apologies, but okay. There's been some the colors of my slides are changing a little bit. I can start. Okay. So good morning, and on behalf of Attorney General Hector Balderas, welcome to this New Mexico Office of the Attorney General's roadshow on the Sunshine Laws, the Inspection of Public Records Act, and the Open Meetings Act. And can everybody hear me well? Did everybody find? No? You can't hear me?
Can't hear you.
No? Is this better?
Yes.
Okay. Try to hold it next to mine. Okay. So let's see. Did everybody get a copy of the Inspection of Public Records Guide and the Open Meetings Guide? We have a few left if you need them. Oh, I haven't. All right, and we've circulated copies of our PowerPoint presentations. And let me just tell you a few things about what we're going to do this morning and this afternoon so you have an idea. We're going to start, my name is Mona Valicenti. I'm the Assistant Attorney General in the Santa Fe office of the Attorney General's office. And my colleague here, Luis Carrasco, is another Assistant AG, and he'll be giving the presentation on the Open Meetings Act. My presentation usually lasts 45 to 50 minutes, and then we'll take questions. And we will break for lunch soon thereafter, hopefully by noon. And then at 1 o'clock we will resume, and Luis will give you the presentation on the Open Meetings Act. Let's see. How many members of, how many government employees do I have in the audience? Pretty much everybody. Okay. Do we have any members of the public? All right. That's good. So has anybody already attended one of these seminars? Okay, so I'm going to have to change things for you. I'm kidding. All right. So let's see. Okay, so I'm going to go. Okay, Mr. Stockwell.
He took it.
He took it. He stole it. Where did he go?
In the thing.
Okay. All right. So we can't do anything until 9 minutes. Okay. Well. So I'm going to be going over the Inspection of Public Records Act, and hopefully I'll help you understand what you have to do when you receive an Inspection of Public Records request and how you have to properly comply with the requirements under the Act in order to comply with the terms of the Inspection of Public Records Act. Now, in New Mexico, the first Inspection of Public Records Act was adopted or enacted in 1947. And at the time, the act was very short. It only provided citizens of the state of New Mexico with the right to inspect public records of the state. The reason behind the inspection had to be a legitimate one. And there were only 3 exceptions to the right to inspect. But then, in 1993, the legislature overhauled the act, and the act took its present-day format pretty much, subject to some amendments that have taken place since then. And back in 1993, the legislature declared the public policy behind enacting the act. People who are standing in the back, there are a few empty chairs up front if you'd like to come and sit, because I believe we need to be seated for the fire marshal's I promise I won't pick on you because you're sitting in the front seat. There are 2 seats right here now. Okay, thank you. Thank you. So the legislature declared the public policy behind enacting the Inspection of Public Records Act to be that all persons are entitled to the greatest possible information regarding the affairs of government and the official acts of public employees. And because recognizing that representative government is dependent on an informed electorate, the legislature declared what I just said. All persons are entitled to the greatest possible information regarding the affairs of government and the official acts of public officers and employees. And the citizen's right to know is the rule, and secrecy is the exception, is from a quote from a 1977 Supreme Court case, Newsom v. Alarid, where the courts have interpreted the act, and unless there's an exception in the books or in the statute, the right to inspect has to be freely allowed. And the persons, so as an integral routine part of routine duties of public officers and employees is to allow or to provide for inspection of public records. You're going to have to bear with me 1 second. I'm going to put my little clicker back on. Because otherwise, something's working today. No? Okay. Okay, so now let's turn. So if you want to follow in the guides, you can turn to page 2. We have the law in bold, and so now let's turn to section 14-26, which has a whole section on definitions. And the first one we're going to go over is public body, and you can read and you see that, unlike the Open Meetings Act, the Inspection of Public Records Act applies to all the executive, legislative, judicial branches of state and local government, and all entities created by the Constitution. And a person is defined as any individual, corporation, partnership, firm, association, or an entity. And to inspect is to review all public records that are not excluded. Ma'am, there's a seat up front here if you'd like to come and sit up front. Thank you. The next important definition is for public records. And you can see from this quote that public records are defined as pretty much all documents that are in the possession of a public body and that relate to public business, whether or not the public body has to create or maintain those records. And it says that those are public records. Public records are all documents used, created, maintained, or held on behalf or by the public body and relate to public business. It's a two-pronged analysis. They have to relate to public business. And a recent case from the Court of Appeals dealt with documents and the definition and added that drafts of public documents are indeed public records. And for the longest time, people would withhold the inspection of public record when it was in a draft format, saying that until it's a final document, it's not subject to inspection. But the court has clarified that, and now any draft of a public record is subject to inspection. Whether it is a letter, a memo, or a contract, draft forms are subject to inspection. Now, examples of public record include also records of public expenditures, email, computer database, email communications, tape recordings of public meetings, and state computer database information, as well as tapes, DVDs, recordings of public meetings. Now, that being said, not all records that are held by a public officer or an employee would be subject to inspection or would qualify as a public record. And those would be, for instance, records or notes kept by an employee for his or her own personal use in the performance of his job, or records that are protected under the law because of one of the exceptions we'll go over. And that's it. Now, one thing I'd like to mention in passing is that emails on private accounts. So some public officers or employees may use their own personal email accounts to discuss public business. If you're doing that, then the email communications would be subject to inspection if somebody were to require their inspection. And that happened in the case we got a complaint against a member of a public body who was communicating from his home on his personal email, from his personal email address, But as long as he was discussing public business and it related to information related to public business, those emails were subject to inspection when he received an inspection request, because the user was in fact creating a public record and maintaining it on behalf of the public body, albeit on his own personal computer and email account. So that's something to keep in mind. The next definitions that we need to quickly glance over are the definitions of file format, and that is defined in the Act in section 14-26 as the internal structure of an electronic file that defines the way it is stored or used. And so if you, so that would be, for instance, a Word document, Word is the file format. WordPerfect is the file format. And that is important when you receive inspections to request to inspect the electronic records. So you only give them to the requester in the file format in which the document exists at the time of the request. You don't have to convert documents. Protected personal identifier information is a new definition that was added in 2011, and that one deals with is defined as all but the last 4 digits of the taxpayer's identification number, the financial account number, or driver's license number. And it's all but the year of a person's date of birth and a social security number. So the Court of Appeals has, in a recent case, this addressed the presence of personal protected identifier information from a public record. So in the case of Cox versus the Department of Public Safety, it involved a citizen's complaint against a police officer, but it was a private citizen complaining against a public employee. And so when that citizen had included his name and personal identifying information on his complaint form, the court held that that information was not necessary and could be redacted because of the fear of identity theft. And it didn't relate to public business, so that information was probably redacted from the document. And so that's something that may be redacted from public records when you get inspection requests. The last and most important definition in the Act is found in section 14-26 again, and that is for custodian. And custodian was an entity that was created back in 1993. And that is defined in the Act as the person designated by the agency who is responsible for the public body's public records, regardless of their location. So even though I work at, let me take an example that came up recently, the public body, and I have, let's say it's some board, right, that has public records. And after 3 years or after 5 years, I have to send my records to the State Records and Archives for retention purposes, right? They have to be archived over there. Even though the records are no longer in my possession in Albuquerque, at the office in Albuquerque, they've been moved to Santa Fe, I am still the custodian of public records for those documents. So if somebody asks me for records dating back to 1990, and those records are only at State Records and Archives, I'm still the custodian responsible for them. I have to go make a trip to Santa Fe, go through the boxes, find those records, and give them to the requester. Now, the custodian is a very important person, and I'm sure some of you here are custodians of public records. And that custodian, under section 14-27, has been given specific duties under the Act. And among those duties are to receive the requests, so that you always address your requests to inspect public records to the custodian of public record. And so now the Act considers email and fax requests to be written requests. That's been clarified back in 2009, I believe. Up until then, only letters qualified. But now emails and fax requests are considered written requests. And the custodian has to respond to these requests in the same medium he or she has received them. So let's say somebody emails your request to inspect public records. So the custodian must now email back that he or acknowledge receipt of the request or submit or send a 3-day business letter, but it has to be done in the same medium the request was received. If it comes by mail only, then the custodian has to respond by mail. The Act allows the custodian to use another method of contacting the requester, but he or she must, though, respond in the same medium first. Now, the custodian also has to provide proper and reasonable opportunities to inspect public records. So this means that even though this providing inspection of public records is an integral routine duties of public officers, you don't have to allow for a requester to come in at any time of the day or after work hours. You may impose reasonable restrictions for the requester to come in and review the records that he or she is interested in, and but you have to always make it a reasonable restriction. Of course, any request to inspect public records doesn't have to take precedence over the business of the custodian. Let's say he or she is dealing with something else more pressing. But you know that we have to provide facilities for inspecting. Next, in subsection D of 14-27, the Act requires the custodian to provide reasonable facilities to make or furnish copies of public records during usual business hours. And this has been interpreted to mean that a requester may bring his or her own personal equipment to make copies of those records. So let's say I want to bring in a portable scanner and I want to scan the documents. I don't want to pay the copying fee of 25 cents a page. The custodian must allow this, provided it is reasonable, provided you may accommodate that request. So you always have to ask the custodian for, not permission, but if you may do that. And, but then when a requester comes and makes his or her own copies, the public body cannot charge for the cost of making those copies. You won't believe it, but I still get questions about that. People say, well, I've been charged 10 cents a copy or 25 cents a copy, but I had my own equipment, my own camera, my own whatever I didn't bring with you. The thing to remember is, let's say somebody wants to inspect emails. Well, in order to allow for the inspection of emails, you're not going to let the person sit at your computer and scroll down your email. You're going to have to print the emails that are responsive to the request, because the requester wants to see the emails dating back to 2013 that dealt with the specific contract or discussion of this particular business between these particular people. So the public body must make paper copies of those emails and then provide them to the requester for he or she to inspect. Making those copies is part of doing business. It's part of allowing for the inspection. You cannot charge for the cost of having made those copies. Yes, sir?
If the request was to forward their electronic copy of the email, could they do it that way?
They could, provided it was feasible, yeah. Sure. We'll touch upon that in a little while, electronic records. Now in subsection E of 14-27, the Act has a mandatory requirement for a custodian to post an inspection notice in a visible place in an area accessible to the public. And in that notice, and we have a copy of that notice in the back of our Inspection of Public Records guide if you need to use one. The notice states or advises members of the public about their right to inspect public records, about the public body's procedures regarding inspections, including the custodian's contact info, whether it be an email or telephone number, and the reasonable fees that the public body charges, and that the public body has a responsibility to make public records available for inspection. I'm sorry to interrupt, but if you're standing, because there are no chairs, there are a few available seats up front. Right. And you too, sir. There's a seat right here on the second row. Oh, you'll remember. I'm sorry. Okay. All right. Next slide. Any questions so far? Oh, wrong thing to say. Okay, so.
You talked about if you didn't have the document and it was held in archives, then
Yes.
it's your responsibility as the custodian to put archives. How does that correlate with 1428E, which talks about the event that you don't have the record forwarded to another agency?
I was talking about it in terms of you are the custodian of those public records.
Okay.
They are your records, but they are being held in archives because, because of retention schedules, right? You don't have to keep them, so you send them. So they're still your records, you go get them. But if we deal with a custodian who receives an improper request, right, it goes to DOH and said it should have been issued, this request should have gone to DFA because the records are at DFA. That's a different, doing of the custodian of records for records being held by a different agency.
Or even if your office just had never had the record,
Right.
your office had and you forwarded it to archives and
Right.
say, hey, this is...
Oh, archives? Yeah, archives usually, we need to be careful because archives deals with public records and they have to, every agency is still responsible for their own records, right? Because they're your records. They're in storage at State Records and Archives. Records and Archives was
Archives is maintained on behalf of the agency.
on the agency, but you're still the custodian. So, I mean, I don't know how the process works with SRCA, and if you go to them and they have to bring out the documents, but you're still the custodian responsible for the maintenance and care of your records, regardless of where they are held.
Okay.
Because they emanated from your agency, right?
Okay.
Does that make sense?
It does.
Okay.
And then one follow-up.
Sure.
For Department of IT,
Yeah.
I think it works the same way that you're saying that, because they
For
simply
emails?
hold them. Yeah, they hold the emails for all the agencies.
If they do, we don't work with IT at our office, so
Okay.
I couldn't speak to that.
Okay.
So, okay, thank you. Yes, sir.
So by the definition of custodian, pretty much anybody could be defined as a custodian. Do custodians have to be officially designated?
Right, yeah, no, every public agency would designate at least one custodian of
And
records.
there could be more than one.
There could be more than one, depending on the size of the agency. I know the Department of Health has more than one. Yes,
What if somebody submits a request via mail, not email, but just regular mail?
Yeah.
Do you then have to submit the documents to them through the mail? Or could you email?
no, so the request would come to you, right?
Uh-huh.
So you're the custodian of records. You have to respond to that request by mail, that you acknowledge receipt. Let's say you're not going to allow the inspection immediately, so the 3-day letter would go out by mail.
By mail? Oh, that's what you mean by response?
Yeah,
Okay.
that response. But then it depends on what they want.
And then so you can provide the information they're requesting, however.
However it is, let's say they want electronic records, and you have them, if you have those records in electronic format, you would just email them to them. But that's different from the receiving the request.
Thank you.
Okay, thank you for that. Anybody else? All right. So now that we're done with the custodian, we're going to go to the next slide. That's section 40-2A, and that deals with the procedure for requesting public records. And as you are all aware, the Act allows every person to request inspection of public records either orally or by mail or in writing, right? So the Act specifically says that any person wishing to inspect public records may submit an oral or written request to the custodian. Now, when you get an oral request, you must comply with it because the Act says so. You may receive an oral request. But the Act, all the procedures that we will discuss now and all the timelines and all the penalties for not complying with the Act do not apply to an oral request. That doesn't mean you should forget about it. You need to comply, but you're not under the same time constraints as you are when you receive an email or fax or a letter. Okay? Now, I've heard of some clerks or custodians who receive oral requests who ask people to put them in writing, and so that defeats the purpose, but that's up to you. You need to keep records of what requests you get, so you can put them in writing for your own business requirements or to do business. And the Act is very clear, though, that you do not have to create a record in response to an inspection request. So when you get a request for a spreadsheet or a list of, or something that you do not have, Let's say we've received 10 applications for this position at the Department of Health, but we did not make a list, and yet somebody wants a list. So you can tell the people, you can come and look at the 10 resumes or 10 applications we've received, but we don't have a list. So you have to make the information available to the requester. They can come and look at it, but you do not have to create a resume in response to the request. That being said, I know I have some public bodies, some public boards that would prepare the list and send it out just to facilitate the process and to make life easier on themselves and the requester. Ma'am, there's an empty room. Would you like to come and sit? All right. Now, the Act in section 14-28C states that a written request shall include the name, address, and telephone number of the requesters. So this is usually easy to find in letters, you know, because they have letterhead. But in emails, quite often people do not put their address in it. I know it's a requirement in the Act, maybe it needs to be modified, but until it is, this is just a requirement under the Act. And again, it's just for the email. It's so that you may contact the requester when you have to clarify things. Sometimes email addresses are blocked, things go to trash. I've had that happen to me a few times, so even though it was from a person I had received emails before, the email gets routed to trash. And so it's good to have addresses somewhere to make sure that people can contact you when you file requests for records. Yeah.
It's reasonable particularity.
Yeah.
Who decides that?
Let me get to it. I'm just the request of the custodian. But okay, so would you like a piece of candy or something? Because I'm sure I have. Okay. No, I have something. So another requirement under the Act, section 14-28, is that the request to inspect public records must identify the records sought with reasonable particularity. This doesn't mean that you have to pinpoint the exact document by title, right? But you have to give the custodian enough information so that he or she does not have to go on a fishing expedition for all the records in my office, and you should see my office. I couldn't if somebody were to ask for, I don't know what, but so you have to give them an idea about what it is you're looking for. Let's say it's a contract that was entered into last year between you and, well, you've entered into 100 contracts, so which ones did you want to see? So you have to give them a little more information about the contractor. Yes, sir.
What if they were to do a request of all contracts in the last 2 years?
Then they get them all.
Okay,
So
I was
it's
gonna
really
say.
some requests. Yeah. Give good people ideas. Yes, sir.
We have cartographic data that's...
I'm sorry, you have what?
Cartographic data
Cartographic? Or
that's,
maps? Okay, yeah.
that's interagency created, like OSC and DOH and environment. When they request that from the OSC, do I have to direct them to DOH and the other departments to get permission for that, since the document or that data has different agencies in it?
As long as you have it, and it refers to what it is that the requester is getting, you can give it. You don't need permission. It's a public record, right? Anything else? Okay. So. All right, let's go on. I'm reading to see if I didn't forget to say anything, but nothing important. So then, the last thing I'm touching upon on this slide is no reason required. So now, when the Act was amended in 1993, the legislature removed the requirement that the inspection be for lawful purposes only. So now, anybody can request to inspect any public record for sheer curiosity, for gain, for any reason. They don't have to give you a reason, and the custodians can no longer ask what the reason is behind the request. Sometimes we wonder, but you can wonder, you cannot ask the requester. But because the act begins by saying every person has the right to inspect public records of the state. Yes, ma'am.
Thank you. You did say that the oral request doesn't fall under the same type constraints as a written. What is the difference?
I'll get to the time constraints in a little while. Yeah.
Thank you.
Everything else is clear? Makes sense? Yes, ma'am.
I just want to clarify that in the oral request, it can be no matter the language used.
I beg your pardon?
It doesn't matter what language is used to make the oral request. I'm just clarifying that any language will work.
I don't understand that. I mean, French or English or Turkish, what?
Right, like if somebody comes to you and asks in Spanish, then you need to make sure
Well,
that.
see, you're assuming that I speak Spanish.
No, I'm assuming that I do a little bit. But that I need to make a reasonable attempt to understand and find the translator so that that request can be taken.
Okay, that's the first time I hear that. That's interesting. I would assume that if you don't speak English, you would take somebody with you who speaks English because you're not familiar, I mean, you don't speak English, and you make your request known to the custodian. Yes. Yeah. Yeah. I don't know that you have, well, yeah, that's interesting. But yeah, or if you have somebody in the office who speaks Spanish, you say, come here, please translate, you know. But yeah, no, it would be on the requester's, I mean, I gotta assume, I don't know, the requester's burden to explain what it is he or she wants from the information. So yeah, we're gonna get to the report. Okay, before I go there. Wonderful. Let's go to the next slide, and it's out of order on your PowerPoint, and I apologize. My Russian today, I switched two of them. So then, now in section 14-29B is a new section in the Act, and it reads, the public body shall provide records in electronic format if such is available and the requester is requesting electronic records. So you remember the definition of file format, which is the file format in which that record is kept. So if I want a copy of a contract that exists in electronic format or a document, but I had prepared it about 10 years ago, and it's in WordPerfect, and that's the only format it's in, that's what you will get, even though your computer will not be able to read it. You're going to have to figure out how to translate it and read it, but the public body does not have to convert that document into the file format somebody wants.
What is considered excessively burdensome?
Well, we're going to get to it. You guys are not jumping. I have to go to reasonable fees first, right? So with the right to inspect comes the right to make copies, right? And we touched upon it when we said that the custodian has to afford, has to allow a requester the opportunity to make his or her copies with their own equipment if they want to. But the Act also allows a public body to charge up to $1 per 11 by 17, right, inch page. And yesterday, for the first time in my life, I saw what an 11 by 17 page is. It's a mighty big page. I didn't know that. I thought they were like, I think I was confusing 8 by 14 to 11 by 17 because I can't count, right? So I'm an attorney, that's my excuse. So anyway, so 11 by 17 is pretty big. And so for those pages, you may charge up to $1 to copy. But other than that, you know, a reasonable fee is what public bodies agree to. So it can be 25 cents, 50 cents. And in that fee, you may include a fee for personnel time, the time involved in making the copies, but it has to be a reasonable fee because if you're challenged on the cost, the court would look at, is it reasonable? Is this a reasonable fee? And
so that was in addition to the $1?
No. A public body may charge up to $1.
Right.
Up to $1. So you always charge less because your pages are 8 by 11, right? This is 8
No,
by 11.
I had 11 by 17, so I've even been asked for 24 by 36 sheets.
Well, if it's a special page, or let's say it's a map or something
Yeah.
huge, and you have to take it to Kinko's or some outside outfit to make a copy because you can't accommodate it, then you would actually charge what the outfit is going to charge you to make the copy. But you have to discuss it with the requester. I think that once you have the communication going, you can do it. Now, the custodian may charge the actual costs associated with downloading copies of public records to a computer disk or a storage device, including the actual cost of the computer disk or storage device. And those are new additions to the Act in Section 14-29C3. And they're self-explanatory. So if you're going to go buy a CD to put on electronic records and then mail them to the requester, you may charge those costs to the requester. You just have to have a little policy and a sheet with all the costs. And now we come to those excessively burdensome or broad requests. So, if a custodian determines that a request he or she has received is excessively burdensome or broad, the only thing the Act gives you is additional time beyond the 15 days within which you have to comply with the request to provide those records. So I want all the emails that Mr. Carrasco has in his outbox or inbox, since he started working at the AG's office. And so that's going to be 2 years or 4 years worth, 3 years worth of emails, whatever. And it's going to be excessively burdensome to go through all of them to make sure we redact the ones we can redact and provide those records to the inspector. So then the custodian determines that request to be excessively burdensome or broad and lets the requester know, and we take it from there. But you have to let the requester know when you're going to make those records available. You can't just forget about them and say, oh, 6 months, oh, 9 months. It has to be a reasonable amount of time. Because if you recall, one of your routine duties, or integral part of your routine duties, is to provide for those inspections. So you make the requester know approximately how much additional time you need, and then if the deadline is approaching and you haven't been able to comply, you call the person, you let them know that we only got half of those emails. We need additional time to get the rest of them, but we'll give you what we have so far. And so I find that when people communicate with the requesters, things go smoothly. It's when we just decide not to talk to them and take a defensive attitude that things don't go too well. And then in the back of the Inspection of Public Records Guide, in the back of the IPRA, you have a excessively burdensome letter in the back. Okay. Now we're going to discuss how a public body goes about responding to an inspection request. So the Act says in Section 14-28D, the Act reads, the custodian receiving a written request shall permit the inspection immediately or as soon as practicable, but not later than 15 calendar days. So then you see when you get a written request, and all doesn't count, right? We're not counting about. This is for the lady in the front seat who's not listening to me. Now she's texting. I'm going to tell her, no, I'm kidding. Sorry, I'm kidding, I'm sorry. So, you have 15 days to respond to an inspection of public records that comes to you in writing, right? By mail, by fax, email. And so if you're not going to allow this inspection immediately because the letter happens to be sitting on my table, and so they want to see what I said, so I can't give it to you right now. The letter is in archives because it dates back 5 years, so I'm going to have to go to state records and archives to get it, so I will need a few days. So if you're not going to let the inspection occur immediately, then you have up to 15 days to do it. But the Act says, if you can't provide this inspection immediately, and it's not allowed within 3 business days, and you don't count the day you receive the request, okay? You don't count the day you receive the request. So this custodian has to send or deliver to the requester a letter that says when the custodian will allow for that inspection. So we call that a 3-day letter, and it's in the back of the guide. if you need to produce one. But again, the deadline is 15 days. So you see that you have enough time to comply with those requests. You don't have to stop all the work you were doing on some other projects, in order to comply with the request. But because inspection or allowing inspection, again, is an integral part of the routine duties of public officers or employees, you, the public body, must allow inspection as soon as possible under the circumstances. And there's a deadline matrix in the back of the guide that is very helpful. It's in Appendix 1. If you want to take a minute to flip to the back of the guide, it's blue and white. It used to be on page 42, but I dare not say what page it's on.
It's on page 43?
It's on page 43. Yeah, I have it.
So copies of that guide available?
I beg your
Are
pardon?
there any more copies you can buy available?
I don't have it. Well, we have them on our website. You can download them, but if you'd like a copy, just give us a call and we'll mail you. Are we out of all the copies? Anything else on here? Yeah. So this matrix shows what you do when you receive the request. So you don't count the day you receive it, and then the next day you start counting day 1, day 2, day 3. You haven't allowed the inspection because you needed more time. You send out that letter, and then you provide for the inspection within 15 days, unless you've deemed that request to be excessively burdensome or broad, where you have to let them know within 15 days that you're going to need additional time beyond that, a couple of weeks, maybe 3 weeks, 4 weeks, depending on the case. Now, all of this is for accountability purposes. The legislature has added those requirements to make sure, or to put some accountability on the public bodies, right? Because these requests are being ignored sometimes. So this is one way of getting things to be done in a proper way. Now, let's talk about point 3, to forward to a proper custodian and notify the requesters. So as Mr. Stackpole here had earlier touched upon, sometimes the request goes to a wrong custodian. So the request comes to, let's say, the Office of the Attorney General, but, and it's a request for records that are held by the Tax and Rev. So then when the custodian receives the request, he has a duty to let the requester know that that this office doesn't have those records. But we believe that they are held by Tax and Rev. So we're going to forward your inspection request to Tax and Rev, and we think, and we'll let you know that this request has gone to Tax and Rev, to Mr. X, who's the custodian there, and so you can follow up with them. But this is a requirement in the Act. This is what the custodian has to do. Yes, ma'am?
I received an email request for access to records that are not in the possession of my agency. I forwarded it to our agency's record custodian. Do I have a responsibility to respond to that email?
Did everybody hear the question? Yes?
No.
No? Okay, so the question was, this lady has received an email for an inspection request. She forwarded it to the custodian at her agency. And then, do you have a responsibility to respond to that email?
Personally, do I have a responsibility?
No, because no you don't, you're not the custodian of public records. So unless the custodian of public records has a duty when he or she receives an improperly forwarded request to forward it to the proper agency. If no, the Act, does allow for, if you don't know who it goes to, you would let the requester know, I don't have those records. We're not the custodian of records for them, and we don't know who you have to go to. Yes, sir? Yes?
If you have some records that pertain to a request, and you know another agency has records on them, let's say you get a request for all of emails regarding yourself and person X and the other agency. Obviously, you have a duty to provide all emails that you have, and the records custodian does. Are you also required to forward it to the other agency and say, hey, we also received this, and I know you have some records because it's your employee?
Well, you are this one is double, well, for excess of caution, maybe you want to, but your duty as I understand it. You're the custodian of records. You have whatever responsive records you have in response to that request you provide. And you could, in your letter to the requester, let them know that maybe this other agency has some also, because they're the employer or something. But maybe, yeah.
Because the act only talks about if you don't have the records,
Right.
that's why I was curious.
Well, I'm saying if you have some records, you provide what you have, right? So that deals with your duty under the act. You're a custodian of public records, you receive a request, you provide whatever documents you have that are responsive to that request. That's all you have. But sometimes when they're employees, right, they go to different agents, right? I mean, the requester probably does, I mean, I don't know that you have, no, I think that's
Do
fine.
you know
Yeah.
where they're maintained, if you have information to forward the request on to the property?
If you know where they're maintained. If you have records responsive to a request, well, by excess of caution, it wouldn't hurt you to let them know, but no. I think that if you're a custodian, you receive a request, you have responsive records, you provide them. And you can let the requester know that maybe this other agency may have some records, but I don't know that you have, it's not a wrong
If you know
custodian
that
request.
that agency has those records that you don't have, but that are being requested, I think that falls under.
Well, if he's denying,
Proper-
okay, then this one is up. So you deny the
That's
request.
right. You have some records that are responsive. You
Okay.
just know.
Somebody else has some, you alert them, but then you're, okay, if you want to, I don't see why you wouldn't, it wouldn't hurt. I would let the requester know
Okay.
more than, and I guess it wouldn't hurt to forward the request, yeah. Sake of openness, forward the request also. But I don't know that it's required, I don't see it that way.
I agree. Okay.
Okay. Okay. Now, any questions on this? Okay, so you get a request by phone. I call you and I say, I want all your emails for the past year. So you don't have to, okay, so you, I'm sorry. Lame example here is that this lady, you're the custodian of public records? So I say, okay, Madam Custodian, I would like to see all the emails that your director has sent to Mrs. Stackpole for the past year. So you go, okay, fine, thank you. You note it down in your notebook. The allowing the inspection immediately does not apply, right? Allowing these, sending the 3-day letter because you're not allowing it within 3 days does not apply. Doing it within 15 days does not apply, but you have to provide those records. Okay? Because now you'll see later on that if you don't comply with these timelines for the requests, you are subject to penalties. So those penalties would not kick in with an oral request. But I tell you, more often than not, I don't hear people saying that they're receiving oral requests. Although no, there was the KOAB case, right? Somebody put in a phone call and requested records. So people are still calling and asking for records, okay? So you have to comply. It would be best to comply as is required under the law for written request, but if you don't, you're not going to be penalized for it. Okay. Okay. Another duty the custodian has is to redact. I wish I could make this more exciting, but I don't know how to. I have to come up with some jokes, and I'm really bad at that, but one of these days. So another duty the custodian has is to redact exempt information from a public record before allowing the inspection of the remainder of the record. And now, if you're dealing with electronic records or records in electronic format, then Section 14-29A requires the deletion of the exempt information with the corresponding metadata. And metadata is information about data, right? In an email, you can see, or in a document, you can see who's made changes to it and who's looked at it last and who's reviewed it. So that kind of information, if it is exempt, has to be redacted before you provide the document to the requester. Now, in Section 14-21B, the Act deals with the redaction of protected personal identifier information. And the section reads in part that protected personal identifier information in a public record may be redacted before inspection. The presence of protected personal identifying information does not exempt the record from inspection. However, the Act prohibits making unredacted records containing protected personal identifier information available on a publicly accessible website that is operated or managed by the public body. So that's what you have to be careful of. You cannot put that information on a website, but you may redact it from public records before allowing the inspection if it's a regular public record. Maybe not. All right. All right. So now that we're done with responding, anybody have any questions about how to comply with an inspection request? Yes, sir.
Yes. I was reviewing some documents that I had made with a request, and I was informed by the records custodian that they were using a draft policy to respond to requests, and I made an oral request for that policy. Does that count as a request?
Yep.
Okay. She provided me the policy that was posted on the entity's website, and not the draft policy that she admitted to be operating under.
Well, she did, right? So she complied?
No,
She
she
has-
does not.
Well, she has more time, right? She has more time to comply.
Oh, this was close to a month ago.
Can call her back?
Okay, thank you.
You're welcome. Okay. All right, so now that we've dealt with responding, let's see how we deny a written request. So the Act in section 14-211 has a very specific procedure that public bodies have to follow when they deny a written request to inspect public records. And so the Act requires that the custodian is required when he or she receives a request to inspect public records and he doesn't have the records or he's going to deny them because of an exception in the law. The custodian is required to give the requester a written explanation of the denial, and you have to describe the records. So let's say it was for Luis's application. And I'm going to deny it because I no longer have it. He's been fired. I'm sorry. I'm sorry. The reason why the request is denied because the information you're requesting is protected under section 3 of the Act. And then you have to list the names of all the people responsible for the denial, and usually it's one attorney and the custodian of public records reports to that person. And you need to deliver or mail that written explanation of denial within 15 days of receipt of the request to inspect. All right? Now what's important here is that this written request that's not allowed because, this is important because if you don't allow for the inspection within 15 calendar days, that person may deem the request denied. All right? And if you've denied this request, regardless of what you did not provide you with the records, so it's deemed denied. So this custodian is subject to an enforcement action, and the requester may go to court and file a case against you, a lawsuit. I would tell you that this would be premature. Most people wouldn't do that because you can call the person and say, what happened? You can discuss things. Nobody would go to court on day 16. But this is what the law allows. All right? Yes, ma'am.
So if you receive a request by mail, then that means you have to mail that in time for them to receive it in 15 days.
It says within 15 days, yeah, but nobody's using it, yeah. Delivered or mailed within 15 days.
Or postmarked.
That would be good, yeah. Because sometimes the mail is very unreliable lately.
How long does it take business days?
It says within 15 days, does it say calendar? Yeah, I think it's calendar days. There's only 3 business days for the 3 business day letter, 3-day letter.
15 days from the date of receipt or 15 days from the date?
The day you receive it doesn't count. Look at that appendix, right? So you start counting on the next day, and then it's 15 days from there.
After the records recipient receives the request.
After the proper, well, I'm assuming the request went to the proper custodian of records. The day the custodian receives the request does not count. You start counting the following day, and then you have 15 calendar days, which is what, 2 weeks. Okay? Now, so then I said the custodian may be subject to enforcement action in court, right? And the requester may be awarded damages under section 14-211C. So the legislature is making those public bodies, the public bodies will work for accountable and for providing a response. Otherwise, you may face some penalties. All right, so this takes me to the exceptions, and we're going to go over them very quickly. What time is it? 11:34. Oh, okay, so I'll go over them quickly, and if you have specific questions, just ask. So the Act in section 14-1 says that every person has a right to inspect public records of the state, and then the famous word, except, is there. And then the ICRA now has 8 exceptions to the right to inspect public records. The first one is for records pertaining to physical or mental examinations and the medical treatment of individuals. This exception has been extended by the courts to cover mental, physical illness, etc. Exception number 2 is for letters of reference concerning employment, licensing, or permits. So some licensing boards who receive applications, the information in those there could be letters of reference that contain opinion, not factual information about individuals. So that kind of information is not necessarily accurate or could be, the legislature has deemed this type of information to be not subject to inspection because they don't want to have a chilling effect or letting people know who write reference letters that their letters might be subject to inspection that might cause some problems. Anyway, exception number 3 is from letters or memorandums that are managed with opinion in personnel files or students' cumulative files. Again, here public policy steps in, and it's the public interest in non-disclosure outweighs the public's right to know. And again, we're dealing with, we're not dealing with factual information. So you would, for instance, personnel evaluations would not be subject to inspection unless it's the employee himself or herself who's asking to see something. But this inspection aims to protect personnel and student records that contain subjective rather than objective information from seen by the public. And for school personnel, school students file, the FERPA, the Family Educational Rights and Privacy Act, and that's the federal law prevents educational institutions from divulging information about students that other than like directory information and what else? So unless you have, but that doesn't include records created or maintained for law enforcement purposes by a law enforcement unit of the educational institution. Exception number 4 is the law enforcement records exception. This is a relatively big one, because not because of this language here, but because of all the other state laws that come into play in this area, like the Arrest Record Information Act. And this exception protects from disclosure law enforcement records that reveal confidential sources, methods, information, or individuals accused but not charged with a crime. And law enforcement records, this section goes on to say, include evidence in any form received or compiled in connection with any criminal investigation or prosecution by any law enforcement agency, including inactive matters or closed investigations, to the extent they contain the information listed above, which is confidential sources, methods, information, or individuals accused but not charged with a crime. But this law enforcement records exception, as I mentioned, doesn't protect information subject to disclosure under the Arrest Record Act. And that would be records that identify a person who's been arrested. In addition, information containing posters, announcement or lists of fugitives, wanted persons, court records, public records of traffic offenses, accident reports, and original records of entry compiled chronologically would be subject to inspection. Exception number 5 is for my museums. As provided by the Confidential Materials Act, and it only applies if the material donated or sold was not a public record before the donation or sale. Exception number 6 is for trade secrets, attorney-client privileged information, and long-range strategic business plans of public hospitals discussed in the public closed meetings, and that mirrors an exception that police will go over under the Open Meetings Act. We can close a hospital board meeting, exception number 9, to discuss specific type of information. Exception number 7 is our Homeland Security exception, very specific. And finally, exception number 8, as otherwise provided by law. So in the guide, on pages, I don't have them listed anymore, but in the middle of the guide, you have a list of other statutory exceptions that provide for confidentiality for some public records. There are Supreme Court rules, the Constitution, and federal law, and specific statutes that provide for confidentiality of records. So you always have to consult with your attorney, the attorney from the public body, to see whether an exception applies to the public records that are being sought. Now, all the exceptions under the IPRA, 1 through 7, are permissive. So even though the law says you may deny inspection based on exception 1, 2, 3, 4, 5, 6, 7, if you want to, you may provide the records. You don't have to withhold them. This is different than these other statutory sections I'm referring to. So these, as otherwise provided by law, if there's a specific statutory exception, you may not violate it and provide the record. You may subject yourself to some criminal penalties. So you have to be careful about that. It's a different analysis. You may be allowed to release a record. And finally, up until the case of the Republican Party of New Mexico versus Tax NRF came on board, we used to have a countervailing public policy exception on the books that allowed public bodies to deny inspection of public records based on this public policy exception. We no longer have this exception available. After the Republican Party, unless you can find an exception in the guide under the IPRA, an exception in the books, in any statute that pertains to your public body, or rule of the Supreme Court, or in the Constitution, a privilege, you must provide the record. So you have to be able to cite a specific section of law in order to deny an inspection. Okay. So now the damages. Under section 14-211, we touched upon the damages that custodian could be subject to for failure to provide a written explanation of denial. And so if somebody files an action in court and he or she prevails, then the damages that could be awarded are up to $100 a day until a written explanation is provided. The date the court starts counting is from the date of non-compliance, and all those funds are payable from the public body's funds. Now, who may enforce or who's allowed to enforce violations of the Inspection of Public Records Act? Well, the Office of the Attorney General is empowered by the statute to enforce violation. And the way the office handles this is first of all by providing these educational seminars so people know their rights and their duties under these laws. So public bodies learn about their duties to comply with the county requirements. and members of the public know about their rights to request records. And in our office, in the Open Government Division, we receive complaints from members of the public regarding alleged violations by public bodies. And so when we get the complaints, they get assigned to one of the attorneys, and we ask for a response from the public body to see what happened, why didn't you provide the record, or, you know, explain why this person is complaining, and then we issue determinations deciding whether there was indeed a violation or not. Sometimes people misread the act and file complaints that are dismissed because there was no violation. And sometimes we find violations and we let the public body handle it voluntarily. So please provide the records. There's no exception that applies. You comply and let us know that you have provided the records. So this is how the Attorney General enforces the act. We don't have the personnel resources to go to court to follow through on violations. We have sometimes, it depends on the case. Individual requesters may go to court, as I said, you know, so let's say you filed a written request, you didn't get a response in 15 days, well, you may go and file an action in court. Again, I think that's premature, but people have the right to do that under the law. The district attorneys in the county of jurisdiction have the power to go to court and enforce violations of the IPRA. I forgot to mention that when the IPRA was first enacted in 1947, violations were criminal in nature. But since then, they're not, so it's just a financial penalty that you have to pay. There's no exhaustion of administrative remedies required to go file a case in court. You can just walk in and file your complaint. You'll see that's different under the Open Meetings Act. Specific statutes of limitations apply, and the courts, after review of the facts, may order an injunction or mandamus, forcing the public body to comply with something. And if the person is successful in court and wins, they may be awarded damages, costs, and attorney's fees. This is, attorney's fees are usually the biggest part of the award, and sometimes they can be hefty sums. Okay, so I'm going to end it here and take any questions you may have, but I just want to remind you that we will reconvene at 1 o'clock to listen to Lisa's presentation on the Open Meetings Act. Any questions? No? Oh yeah, did everybody sign in or find their names on the sign-up sheet? No questions? Great. Well, I hope this was informative, and if you have any questions, you can just talk to me. Thank you.